to our fourth installment of the fourth annual Dean Speaker Series here at MSU College of Law. Each year, we invite several prominent, internationally renowned speakers to come in and talk to us, to engage with us in public discussions focused on some of the most important current topics in law, policy, and society. This year, fittingly, the title of our Dean Speaker Series is Free Expression and Democracy Today. We've had a number of terrific speakers throughout the year. Tom Ginsberg from the University of Chicago joined us in the fall. Vinita Gupta, former Associate Attorney General of the United States. Also Ashutosh Bhagwat, earlier in the semester from the University of California in Davis. And today, it's my great pleasure to welcome Danielle Citron from the University of Virginia School of Law, who reminded me earlier that we had met at a very stressful time for me when I was on the academic market 14 years ago. But, and I did not remember all of the people in the room, but I did remember the incredibly warm welcome of the University of Maryland, where you were at the time, all of the people there. So, of course, I ended up here with even warmer welcome.
That has not stopped, right?
and they hung on to me. So, and Associate Dean David Langfine-Tabachnik will have much more to say about Danielle in a moment. Introduce her. I just want to thank everybody who made today possible. Of course, Dean David Langfine-Tabachnik, our interlocutor today, and also the lead organizer of this event. Frank Aiello, our Chief of Staff, Kelly Mell and Lori McMahon, who in the Dean Suite, who helped organize this. Margie Amory, of course, our events coordinator. Aaron Richard, our head of marketing and communications in the back there. And Allison Garag-Man, who is she here? But our director of IT, who makes all of this possible, including the live stream that's going out to MSU. So with that, I will thank you again for coming, and I will turn it over to Dean Langfine-Tabachnik.
Thank you, Michael. Thank you so very much. And Danielle, thank you so much for being here. It is my great honor and a tremendous, wonderful pleasure to have you here. Danielle, Professor Citron, is, I think it's about the highest honor a university who is into giving out lots of honors can be awarded. It is the Jefferson Scholar Foundation Schenck Distinguished Professor of Law and Chapman Professor of Law at the University of Virginia. She is an international expert on privacy and freedom of expression. She has been, I have to say this is very impressive, the recipient of a MacArthur Foundation Genius Grant. So we have a genius in our midst on our very stage here. She is the author of a recent and widely acclaimed book, Fighting for Privacy, Protecting Dignity, Identity, and Love in the Digital Age. Her work has been published in nearly all of the nation's finest law reviews, the Yale Law Journal, the Stanford Law Review, the Michigan Law Review, the Virginia Law Review, the California Law Review, and the list just keeps going on. She's a member of the American Academy of Arts and Sciences. She's appeared in film and on television and has been quoted hundreds of times in essentially every major news outlet in the nation. Her TED Talk on issues surrounding privacy has been viewed more than 3.5 million times. I'm impressed to say she has given more than 400 talks at major universities, federal and state agencies, and the National Holocaust Museum. She has, prior to the University of Virginia, she has taught at Boston University School of Law, the University of Maryland School of Law, as Michael was just telling. She's been a visiting professor at Fordham Law School, a visiting professor of GW Law School in Washington, D.C. And where we first met was when I was visiting at Washington University in St. Louis, and Daniela was the dean's distinguished visitor at the time. And she has, in addition to all of this, been an interdisciplinary studies fellow at the University of Massachusetts at Amherst. So with all of that, can we please just welcome our speaker to Michigan State University. and this is just, it's so impressive. Our topic for the year in this Dean Speaker Series is freedom of expression and democracy today. So just to open the conversation, might you tell us a little bit about the relationship between privacy, which is in a sense is your topic, the main focus of your scholarship, but for you, privacy is almost a precondition for freedom of expression, which itself is connected in interesting ways to the idea of democracy and citizenship, I should think. Might you tell us a little bit about, open the conversation, what is the relationship between privacy and freedom of expression?
And before I begin, may I just thank you for having me? It's such a delight, and it's true. I met your dean and thought he was such a superstar. I was like a punk law professor. You know, it was like my first year. I was on the appointments committee, and so he created a vivid impression. And it's lovely to be back to be with you, David. So thank you for having me.
Yeah.
So I'm gonna explain the kind of privacy that I think is, and I have argued, is foundational, and why that kind of privacy is foundational and critical to free expression, and how it's not a new idea, right? It's almost embedded in the First, the Third, the Fourth Amendment. So it's rooted, I think, in some sense in how we ourselves think about privacy, is embedded in how we think about constitutional commitments. So I write about the privacy. So intimate privacy is the privacy or the information and access to our bodies, our innermost thoughts, which of course we share every second as we browse, as we click, as we read, right? As we search, our health, our sexual activities, our gender, our sex, and our close relationships. And when we have, so you asked, like, what's the connection between privacy and free expression? When we're afforded the ability to decide and set boundaries around our intimate lives, our bodies, our thoughts, our close relationships, it gives us the space to figure out who we are. So it's so central to identity development. And when we have that, when we're afforded kind of that breathing space, it lets us, privacy is never a me, it's we, right? It lets us bring people in. And when we bring people in, we can have those central conversations, not only about our authentic selves, like in figuring out who we are, which is not easy, and well, I'm still working on it, I'm 56. You're like, you know, we're always working on
Who am I after
right,
all?
the project of figuring out who, right, our authentic selves are, right? And our ideas. And privacy gives us that space to experiment, to think through what we're ready to go on stage with and what we just actually want to keep to ourselves. And it enables us to form these thick relationships that, as you said, like, what's the connection between privacy and democracy? That is, it's only when we feel sort of safe and comfortable, able to speak, that we can then go on stage and participate as citizens. And so the commitment to protect our intimate privacy, whether it's vis-a-vis individuals, vis-a-vis governments, vis-a-vis businesses, right, everyday businesses, it's a crucial affordance that enables us to figure out who we are, enables us to love other people, enables us to feel self-esteem, that then we can participate in ways small and in ways profound.
Sure. So one way to think about it, you're talking about the idea of intimate privacy. There's also a sort of entangled with this is sort of almost an idea of intellectual privacy as well, that you might think in order to form an identity of my own, it requires me to be able to think about myself in a certain set of ways, being able to share information with an interlocutor in certain ways, try on ideas, speak about an idea. What would it be if this was true? Posing hypotheticals, even if they're zany hypotheticals, and exchanging data. And all of this has to take place under sort of some form of a shield of privacy or some sort of walls around. And so if you think, and I think this is absolutely correct and crucial to human development and a foundation of morality in many respects. How do you see the situation with regard to data as we advance technologically? So we can think about this conceptually and abstractly, and as a foundation of morality too. But how do you think of this as technology evolves? And we historically thought about exchanging this type of information, engaging with one person, but now when we do it with one person, the whole world is watching. There's an eye in the sky. And how do you think the law is or is not responding? Do we have an inoptimal amount of privacy? Is there too little to have this important phenomenon taking place?
Yeah, so we know, of course, all of our interactions are mediated by technology. So that is, whereas it was true we freaked out about computer data banks in the 1960s that prompted the Federal Privacy Act of 1974. We were worried about databases being misused by government and its overweening power. Now everything we do is, I don't have my phone with me. I always whenever I say, where's my phone? This is my soul. Right? Everything that we do is mediated by companies. And it's true that wherever we are, there are often surveillance devices. That is CCTV and automated license plate readers, and all the ways that either private actors on behalf of government, either for purchase or for gift or for cooperative arrangements, are so providing that data to governments. And your question was, is law protecting us?
Yeah.
And we are woefully unprotected. In the United States, vis-a-vis companies, we have a consumer protection model to privacy, which essentially means, and this is not to disparage all of the cool interventions at the state level, so state lawmaking, I love state AGs, the Federal Trade Commission, but the basic promise is that just don't lie, right? You can collect, amass, share, use, exploit, sell personal data as intimate as humanly possible, and you can sell it with no problem, so long as you don't lie to us in your privacy policies, right? And there are some small kind of road bumps in the way, some small friction. California lets you opt out. There's now a delete me data broker database. I'm thinking of if you're a California resident, which I'm not, right? Most of us live in states in which the law is so suboptimal as to be silly. And to the extent that we have law, it's very procedurally, it's almost like procedural due process. You have a right to know, you have a right to correct. Do you ever invoke any of your rights? No, we interact with countless apps on our phone. We probably wouldn't have the time to read these. I know we wouldn't. It would take us 53 days to read.
We never get through it. We never get to buy whatever it is we're trying to purchase, and that they're trying to shove at us so quickly at the same time.
Right. So our information capitalism, or surveillance capitalism, as Julie Cohen and Shoshana Zuboff call it, is there as a free pass, right? So we live in an age in which our data is monetized, and the problem is, for all of us, we all know we want and we expect and we deserve privacy. But the mismatch is that when we share our data, it's not visceral. We don't feel the data coming out of our fingers. You know what I'm saying? We don't experience it. And a lot of the harms that ultimately come about are downstream. So the insurance premium that's raised, the jobs you never know, you never, ever could possibly get an interview for, that you were rejected for, you don't know about. The health insurance premiums. So
wait, hold on. This is shocking to me. So you're saying while this is all going on, digital profiles are being created of us from all of these sources that you're mentioning, and my automobile insurance premiums might go up, or you might one in the world might not get a job that they don't even know they didn't get the job. They didn't even get called for an interview. Based on how does that process unfold? How would that come to? How does that happen?
Something we were talking about last night. It might be, let's say, if some of this data seemed to be paired directly to one's ability to drive carefully or not carefully, that might make a little sense, right? But the data that data brokers are collecting and then selling to insurance companies are 10,000 data points on every one of us. So it is predictions, ranking, rating, and scoring us for the likelihood of type 1 diabetes, of heart disease, the kinds of porn that I like. I mean, I don't, let's just say, I'm not a big porn user, but in the work that I do on intimate privacy, I got to know what Pornhub and the other non-consensual intimate imagery sites, of which there are over 9,000. I got to know what they're doing. So you don't really want to know what my computer is up to all the time. I had to learn University of Virginia when I started 5 years ago to say, y'all, my computer's gonna have crazy stuff, like both at home and at work, because I have to know the bad parts of the internet are my work. So
you put that out there up front,
I absolutely like, no problem. We understand. We've read your scholarship. We get what you're going to be doing. So I use that example because there's the most hits that any website has of every site is Pornhub. 3.5 billion hits a year. It's more hits on Pornhub than there are human beings, right, with an internet access. So all of that is to say is that data brokers are gathering 10,000 data points on every one of us. Those are predictions and what we browse, what we read that we don't like, but the algorithm and the risk assessment doesn't care that you don't like it or that you're looking at it in opposition. And so to the extent that your insurance premiums are increased, it's not necessarily based on anything rational. It's like sort of pattern, different uses of automated systems that find patterns that make predictions about.
So they're basically making Bayesian predictions going forward of what will happen, given all of this data, what is the risk analysis and what might happen to you, and so pricing this out accordingly.
Right. So David, who's on my computer? It's not just me. Let's assume that I have a 5-year-old son and a 15-year-old son. I don't, but I have 2 daughters who are in their 20s. But let's assume I did. And my son is an avid gamer. And you know what I'm saying? Like, it's not necessarily about me.
And he uses your phone.
And he uses my computer and
Or
my
your insurance is going to go up or down now because of gaming. We don't know.
That's the thing. Maybe gamers are risk-seeking. I'm like such a scary grandmother when I drive because I learned to drive at 30. So that wouldn't be fair to raise my insurance rates. That I'm literally a grandmother when I drive. I mean, I'm not yet one, but I'm so slow. But it wouldn't be fair because they think I'm a gamer. So all of this is so imprecisely matched to our actual risk profiles. And we have so little say and so little control. And even if we had sort of control-based rights, it wouldn't really help us. As you were saying, we don't have time to read all of it.
So what might be, how do we begin to rein some of this in? Who should have control over this? So people seem all too willing to hand over this information in a certain way. There's just a couple of clicks and you want to buy the item or whatever it is, you just keep saying yes and they record. What would be ways to, I'm a private law person. I think in terms of sometimes the idea of a fiduciary duties, information trusts, how might we think of the people who carry or are in possession of all of it? They may be in possession, but maybe they're not the final owner. Maybe they, do you think they should have some residual responsibilities to the party whose data this is?
Yes. So it's always fun when you're in heated agreement with someone. You know what I mean? Like, that's always a good time. But, I, in my book, conceptualize intimate privacy as a civil right. That is not just a right in which we need anti-discrimination protections, which we do, but we also, it's a right each and every one of us should enjoy in the way that Robin West and even the Civil Rights Act of 1866 understood. There are certain rights that each and every one of us deserve to flourish. And those rights come with serious responsibility. So we think of, employers or schools as the stewards or guardians of students' experiences. So as a university, right? Dean, I see you, right? We're the guardians of our students' experiences and we have responsibilities. And part of those, as the holder of massive reservoirs of data about us, that we ought to understand governments and businesses as the stewards of the data, right? And responsibility should include not just thin procedural protections, but protections that amount to don't collect if you don't legitimately need it for a specific person. And once that purpose ends, bye-bye. You get rid of that data. We shouldn't be in the business of collect it because someday it's valuable. Our data is too important about the story that it tells about us. And it shouldn't be collected, sort of like an anti-collection imperative is how I describe it.
So you think that they should not be able to sort of combine all of this and aggregate it and then search it and over-search it and then repackage it and sell.
We shouldn't have it.
This whole industry should be stopped. You think
Buy.
it should not? And that they should be liable if they do anything other than this for what their purpose. Just like we have, we think of educational records and we think of FERPA or we think of
Which
Privacy
is
Act.
super imperfect, of course, FERPA.
Right.
For lots of reasons that
Sure.
have nothing to do with young people.
Right.
They can't even have access to their records until they're 18, right?
Right.
But yes, at the very least, there are commitments. Those commitments are pretty thin in the in FERPA as well as COPPA, right? Those are thin commitments, right? Like you can check and make sure it's accurate. You can't say you can't have it.
Right.
And I think like a first order is saying we have to think hard about the entire project of collecting, right? And that is a more substantive commitment than just saying you can look to see if it's accurate, right? And maybe correct it if it's wrong, right? We've given permission, like our default is yes to collect because we don't have enough, we don't have enough law to say no.
We don't have enough
one
law.
of the
Yeah,
five
sure.
things.
I think that's right. Do you think there's also a feature of this? Do you think people are fully aware that all of this is going on? That they wouldn't be so quick to say yes,
Right.
that they knew that their health insurance prices might go up, or their auto insurance prices go up, or they could be declined health insurance. How far does this go? I mean, you go to the pharmacy and they always ask, are you a member of the CVA? They want you to put your card in, or keep track of you, and then they print out this long thing. Do they keep all this data? They figure out that you bought cough drops the other day, so you probably are sick. If you keep buying them, maybe your insurance rate should go up, or I mean, you could probably figure out a lot about people by just, never mind prescription products, just ordinary products that you buy in the drugstore. Does that play into this as well?
Oh, absolutely. That is like our dossiers
Right.
that are amassed by data brokers and then sold to insurers and sold onward. Where do they get that data from? They're getting it from CVS. Kroger is actually, believe it or not, I know a grocery store.
Yeah.
Do you guys have Kroger and Harris Teeter? Okay.
Yeah.
They are literally a data broker. In fact,
They make more money on the data than they do on the food.
In fact, they have their analytics project.
Pretty soon the food's just a losing leader. You put it out there to get the data.
It's shocking. I shock my students with this, but like, I guess the precise location of the Cincinnati office where they are doing all the data mining, it's called, I think, 581, because it's the longitude and latitude of where they're located. Wow. It is literally a data broker. They are amassing all the information that they have, of course, that we provide them through our Harris Teeter or Kroger cards. It also includes their cameras in stores to see where we're lingering. Like, what are we looking at? We don't buy the Pop-Tart. We might buy the Pop-Tart. That seems so benign, right? But it's being combined with data from other data brokers. And then it becomes an enormous amount of information about us. So it is the alcohol swabs that I buy because I've got type 1 diabetes, or it's the aspirin I buy because I'm worried about my heart condition. It becomes immediately clear how intimate it is. So about the body, about one's health, about one's sexual activities. You buy a condom. Like, think of all the ways that even at Kroger, right, our grocery store, they're a data broker, right? And Facebook and social media companies are simply advertising companies. Well, let us not be fooled. It's not about connecting us. Are literally just what they are, right? That's how they make their billions of dollars.
Wow.
And so it's, in many respects, you asked, would people object if they understood? And I think if you survey them, as my friend Chris Hofnagel and others have done, and you explain to individuals what's afoot, they don't like it. Right. Do you know what I'm saying? It feels like, what are you talking about? People look at me like I have 20 heads. Like, what do you mean we're doing all of this? Right? And we are. And, why not regulate it? Why is the private sector so deeply unregulated? Right. In the late 1960s, when we had hearings, like weeks and weeks of hearings about databases of personal information, which right now, sadly, I feel like my field is so hot. Like, I write about the Privacy Act of 1974. Who knew it was sexy? It is so deeply freaking sexy at the moment, right? With those employees going in absolutely ultraviolet and illegal ways, entering databases of the OPM with the most sensitive information, right? There was at the time that the Privacy Act was being debated, Senator Sam Ervin and Senator Barry Goldwater, like the most conservative Republican and a Southern Dixiecrat, right? They were in heated agreement that massive databases of information in the hands of both the public and private sector were terrifying, right? That it would enable social control, that they needed strong safeguards. This is heated agreement, right? Now the lobbyists get to Congress, and so we passed the Privacy Act of 1974, which only governs federal agencies. Still really valuable law, but it only governs federal agencies. But at the time, there was nearly heated agreement among Congress when you heard members talk about what they were worried about. They worried about massive databases of information that would enable putting people on blacklists. Right? Like you couldn't get a government contract or a license because there was something indicating in your files, right, that was negative that you could never dispute, right? And they worried about the kind of, this is Goldwater, manipulation and social control, right? And as one of the witnesses says, this is Arthur Miller, and then echoed by Senator Percy, 1984 isn't a year, it's a state of mind, right? And so we had a very clear bipartisan understanding that databases, massive databases of information, not only needed congressional authorization, but they needed safeguards, right? We unfortunately didn't regulate the private sector, right? And so we were at a precipice. We could have, right? And what seems to be a bipartisan agreement now, like literally Sam Ervin and Senator Goldwater would be rolling over in their graves right now, screeching, don't be doing this, don't go into the OPM, GSA, DHHS databases of all this incredibly sensitive information about everyone, right? And so, it is just, you said, like, what would people think? Right? We even have congressional norms around this, right? This is not okay, right? And the costs are profound, both to individual development and the inputs to democracy and free speech.
Yeah, in keeping with this line of thought, in terms of becoming a full participant in society, in a democratic culture in society, you have this example of somebody in a hotel. A lawyer, I think, if I'm right. And this can show the ways in which the absence of privacy or such breaches of privacy, and I'll ask you to just explain this example, can really curtail one's ability to participate as a full citizen in any community, or even participate as a full-bore professional, as this person might have. In this fascinating example you give in your book.
And thank you for inviting me to talk about it, because I think it seems so abstract when you talk about data, to think, how could this really affect me or my loved ones? I think telling individuals, like bearing witness to their stories, is so important. So I'm going to use Joan because that's the name that this new lawyer chose for herself, for me to tell her story in the book. But she was first-year associate. She just graduated from law school, top of her class. And she went on she was accompanying a partner in a deposition, and they had to travel. So she stayed in a hotel room. And when she returned after the deposition, she got an email from someone calling themselves Not a Bad Guy Too. And the email had, like in the body of the email, had a clip to a link of her showering and urinating, undressing in the bathroom of the hotel. And the person says, if you don't send me more nudes in 48 hours, I distribute this to everyone you know and all over the internet. So she calls her law professor, who's one of my closest friends, privacy colleagues. I speak to Joan. I say, Joan, obviously this is an attempt at sextortion. You've experienced a few privacy violations here, video voyeurism, like non-consensual taping. The person is threatening to release your nude images and trying to extort you of more nude images, what we call sextortion. So I talked to her and I said, listen, half of the time, it's true of my experience, they don't actually follow up on their threats. It's like they've done it to a lot of people and they're fishing to see what kind of more nudes they can get. But unfortunately, this person did follow up on the threat. And the next day, so within the 48 hours, he had scraped, we presume, the person had scraped from her LinkedIn all of her contacts, so all of her law school classmates, the colleagues at her firm, partners, associates, anyone she had interacted with professionally. That person sent an email to each and every one of those people and CC'd Joan. And what it said is the email looked like it came from Joan. So she was BCC'd. So she saw what was going on, like as it's unfolding. And it's like Joan Stott, her last name. This wasn't her real email, like a spoof of it, at protonemail.com. And the email says, look at me in my natural state. I'd love to know what you think. And at the same time, it's being posted all over the internet. So on Pornhub. And so the video has embedded in the video is her full name. like the title, if you click on it, you see the title is her name in the shower, her full like first and last name. It then spreads not
So it'd be
only
like Jane in the shower, and you click here, and then
Jane
then
with her
you
last
see
Joan
right.
with her last name, which was a
Right.
distinct last name, in the shower, right? And it's not just
Yes.
Pornhub. There are over 9,500 sites whose raison d'etre is non-consensual intimate imagery. So it is like the most suspicious, the sites you can't even get in touch with, like, right, all over the internet. And she goes into work, and I can explain to you a little bit about the project of trying to get this taken down, which was impossible because we have a law immunizing, shielding from liability these websites for user-generated content.
Right. We'll get to that in just a minute. In the 2:30 is what I
Yeah,
think
we're
you're
going to
referring
get
to. Yeah,
we'll get to 2:30, but I think you asked me like about the human experience and how it changes your willingness to engage and the inputs to democracy.
Yeah.
Right. Joan goes to the partner the next, when it starts happening, and he is so lovely. But she explained to me that she saw herself through his eyes, right? Like it was so painful to talk to him because all she could see was him seeing her showering and urinating. You know what I'm saying? Like her self-esteem was shattered. And she and her boyfriend were planning on getting married, and they put that off for 3 years because she said, how can I have a wedding? This is all over the internet. Like I can't, she shut down all of her social media accounts because it even though it was a great way to stay in touch with all of her high school friends and her law school friends, many of them had seen the video. And she was like, this is yet another vector, as we talked about, for this perpetrator to find her, to torment her. Like any outlet, she pulled herself out of, including LinkedIn, right? And so the costs to democracy are in our face right now, right? She is gone from any engagement with any online activity. And she can't even trust, she had serious PTSD. And she would often text me and say, my phone is a little wonky today. He's in my phone. And I would say, Joan, like, I understand why you feel this way. I get it. But it's probably like she couldn't feel safe anywhere, right? And for years, like, so when this first happened, I met her about 6 months later, and like in person, and she was so painfully thin. And she said, I've lost like 40 pounds. She was going to the gym. Her fiance would walk her to the gym every night after coming home from work at like 9 o'clock. And she said, I don't want to be recognizable. Like I want to be erased, right? And that's true. So I interviewed 60 people from around the globe who've had these kind of intimate privacy violations. And the theme was the same. That is, they either gained a tremendous amount of weight or lost a tremendous amount of weight so that no one could recognize them, right? And so often, victim for victim, including Joan, would get tattoos. And, for Joan, it was her grandmother's name. And she said it was because her grandmother would always be there. Like she was protecting me. She helped me reclaim my body, right? And so, the costs are emotional, they're economic. She was going to apply to clerk, and she was on her law review, top of her class. And she was like, I don't want to have to explain this to judges, like I can't, right? And she stayed in her job, which thankfully she did not lose her job this happened in 2018. So she stayed for 6 years. And then finally has gone to an in-house job. But she said she didn't move because she was terrified. The idea of possibly moving seemed an enormous task because you'd have to explain it. Because all the content is still there. And she didn't want to have to change her name, which some victims of non-consensual intimate imagery do, like the founder of the Cyber Civil Rights Initiative, where I'm the vice president. Holly had to change her name.
So it's a little bit like identity theft, but at the most basic and most personal or intimate level.
Yeah.
This is a great example of an area where the type of activity that's going on is sort of both an incredible sort of intrusion and loss to one's dignitary interest, and also for the general public, that has knock-on effects there too, but also there's also an economic loss where her career doesn't progress, and then the public doesn't get the economic benefit of the services that she would be able to otherwise render. And then all of the investment in her career that's come in that the universities have put forward to produce her, and her family has put forward. So there's both this huge dignitary loss that's causing the personal sort of psychological removal of herself from society, and then also the economic. Given all of this sounds to me like when those two things align, usually sometimes the fireworks come where it's one but not the other, that the dignitary interest is obvious, but there's a lot of money there. And so this looks like they might kind of dovetail. On the other hand, there's a lot of money in the balance too, but these are areas you might think that law would be implicated. What do you think might be the types of remedies for these scenarios? I mean, you quickly mentioned about 230, Section 230. The other, might there be private law remedies? We could have just simple regulation. Could we have private regulation? Could we, in this case, I don't know, you think hold the hotel liable, the service providers of the internet, but that's the 230 issue. How do you find this person? Criminal liability, that at least if it wouldn't provide a remedy here going forward, if somebody knows they're going to be in real trouble for this. What among those, might you speak to those different options?
Yeah, and can I depress us the least? Okay, yeah. I'm so depressing.
Depress us and then cheer us up.
No. Oh, so you want to start depressing? I was going to start.
Start cheering. Okay, good. That's fine.
Well, in some respects, right? So when we first started this work, Dr. Marianne Franks and I, with our founder, Holly Jacobs at the Cyber Civil Rights Initiative, Holly was a victim of non-consensual intimate imagery. She had to change her name. And so we started an advocacy group focused on changing legislation. And at the time we started this work, there were 2 states that criminalized the practice of intimate privacy violations involving non-consensual intimate imagery. And it's a decade later, so we've been doing this work since 2013, plus 2 years. We now have 49 states, DC, Guam, and Puerto Rico, with laws that ban non-consensual intimate imagery. We started with Maryland, because I was at Maryland, and Senator a state senator, John Cardin, got in touch with me. So that was the first law that we worked on. And Marianne has tirelessly worked with legislature with me kind of bouncing in at times. And they're not perfect, the laws. They're mostly misdemeanors. And that leads to their woeful under-enforcement, right? They're misdemeanors, and then law enforcement have the attitude boys will be boys, turn your computer off, like you're making a big deal out of it. So we have a lot of work to do in terms of really teaching law enforcement about local law enforcement and state that the tools that they have and why they should take it seriously and why it's so profoundly harmful. So I think it's a hopeful story of law as our teacher, right? That victims, when you tell them there is at least some possibility, that law might see them, it's kind of everything to feel like there's someone to go to, right? Though it's true that it's a mixed bag in terms of its enforcement, right? And then you ask, well, what about the hotel? What about,
that first part is quite akin to the civil recourse view of torts to some extent that Goldberg and Zapersky are
yes, and there is now in the Violence Against Women Act that we weren't able and still haven't, though we've reintroduced this bill 10 times. We have a federal proposal for a federal bill. Now, though, in VOIA are civil penalties for the posting of non-consensual intimate imagery. And I'm glad we did it. But of course, we have torts like the public disclosure of private fact, and intrusion on seclusion and intentional infliction of emotional distress. The same problem with the VOIA remedy is the same problem of, I think, very applicable torts, which is it's hard to get a lawyer. Right. It's great in theory, but hard in fact, right? The practical reality is that you can't get a lawyer. Pro bono or otherwise.
Might that be a role for super compensatory damages? So imagine you're not going to help the actual person.
Pocket. You literally need
that's a great point.
To pay.
Yeah, you need somebody to hit them with the super compensatory damages.
I'm ready with the triple everything damages, right?
Yeah.
No, but Section 230 means...
Yes, so let's talk about 230. So what happens there? What's going to stop? Because that might be something that would ordinarily put a stop to this, right? Yeah. Somebody's going to be just wild. The trial lawyers get the part. They're going to find it.
I love those trials. And Carrie Goldberg is an amazing one. We have lawyers on the beat here, right? But
there's no one to go after.
We're trying, but there's a law passed in 1996 called Section 230C of the Communications Decency Act. The law was basically an anti-porn provision. Most of it, good luck, gets struck down, rightfully so, right? Porn is protected speech. And what remains is a provision that was meant to encourage self-monitoring, right? And so it provides an immunity for leaving up content. We're not going to treat you as a publisher or speaker, and then taking down content in good faith. And the proposition was, we don't want it to penalize sites that are trying but doing an incomplete job, right? They're filtering, they're moderating content. We don't want to punish them for trying, right? And that was the goal. That was the idea between for Representatives Cox and Wyden, who drafted this provision. But it's been interpreted in such an overbroad fashion that even if a site encourages, solicits non-consensual pornography, deep fakery, sex videos, even if they're literally in the business of crimes, right, they're immune from responsibility if they haven't created the content themselves or partially created the content themselves.
Even where they know, if they have actual
course,
knowledge, or
absolutely.
as the Second Circuit calls
In
it,
the-
red flag knowledge in intellectual, in IP, in intellectual
Right.
property, there's still no liability?
There's still no liability. Judge Wilkinson, in a Fourth
Yeah.
Circuit decision, Zoran, which was a year after the bill was passed, so 1997, finds that distributor liability is a species of defamation liability, and therefore knowledge does nothing, they're immune from responsibility. So since then, even with knowledge, right, there's an immunity. So immunity is
Even with a takedown,
broad.
how about a takedown notice? Would that, do those work? Does that, if they don't comply with a takedown notice?
No, that they don't work because they're immune from responsibility.
Entirely.
Meaning entirely. There are some exceptions. Federal copyright law. So if you've taken the photo yourself, you can try. They still ignore you. So Holly, our founder, Joan, went.
That's so right. So you think of makers. You think if somebody made the photo themselves, they have they have artist moral rights in it. It's a
Which
function
seems
of copyright.
frankly absurd, right? But when
Yeah.
Holly went
It doesn't work?
our victims go, you know what they say? Sue me. Sites are so egregious.
Mm-hmm.
They know that victims have very little funds to hire a lawyer.
Right.
And so unlike the Movie Picture Association, where copyright works and we've got
Sure.
copyright ID taking stuff down immediately, for the everyday person who doesn't have counsel, the lawyers, or sorry, the websites themselves just say, sure, sue me. I'm not taking it down.
But if they pursued it on that copyright issue, if they do have a copyright, would that perhaps
If they took the photo themselves.
If they
and
can show that-
If they can, yes.
then they can get past the shield?
Yes.
Then, so that might, is that,
I'll take it.
Is that an area where you could possibly get to super compensatory damages?
I don't know about the super compensatory damages. I know
Yeah.
it doesn't work well in practice. It doesn't
Yeah.
mean that I will take that tool off the table. Like
Right.
I always tell my students, I'm sure we all tell our students, and for students in the room, like I'll take every tool. Give me a tool, I'll use it. Right. So for victims of non-consensual intimate imagery, like if that's a tool in the toolbox, let's try.
Right.
It ends up, because of the problem of lack of counsel, that it's theoretical rather than real.
Not terribly pragmatic.
And I don't think there's I don't think
Yeah, there might not
super
even be
competitive-
some.
I don't think so. But I'm sure I could get my friends in the audience who are IP
Yeah.
lawyers. I'm not an intellectual property lawyer. I think it's the wrong tool for the project in terms of the theory. The normative value is not that it's property, right?
Mm-hmm.
It's a commodification, objectification, denial of personal integrity and autonomy. Like it's not in some sense like my creation of myself. Holly was like, it should never have been shared. It's not something I want to profit from, right, in that copyright way.
Well, mightn't you think that there's a property interest there, that all of those things you said are true, but you should have a right to control that, and that could be conceived of as a property interest. But you wouldn't want to go in the propertizing direction.
My concern is that it's further commoditization.
Yeah.
If we could understand property in a much more sort of lock-in, respect, respect for the autonomy of the self, maybe I'd be more down for the project, but I
Right.
think it's not often how law formalistically understands it.
Okay. So 230 is there a way to understand 230, or what changes should be made, do you think, so that we wouldn't have this unnecessary level of immunity or deleterious level?
I always have an answer, but whether
Yeah.
it'll get passed. So I
Sure.
wrote an article last year called How how to reform Section 230. I've been working on this issue for so long. The piece came out, and Representative Jake Auchincloss called me. You never get the principal on the phone. It's kind of rare. I always talk to staff. But he's like, I love this. Let's write the bill. So I helped him draft the bill. We have a co-sponsor, a Republican from Iowa. We have co-sponsors, we think, in the Senate. And what it would do is you basically have to earn your shield when it comes to intimate privacy violations, cyber stalking content, and digital forgeries. Right. And you could earn it by taking reasonable steps that we outlined, because I've worked with companies for the last 12 years until they decided to burn down trust and safety and content moderation, right? But I know what reasonable steps looks like because I've worked with responsible companies, right? So we embedded in the shield, the law, right, that would say you get the shield if you do these things with regard to intimate privacy violations, cyber stalking content, and digital forgery. So it's narrow, right? And some of those are having a processes of reporting and saving IP addresses if someone sues. Right. That is, like, there are steps that industry takes, right? Responsible industry takes that I think you can earn. You shouldn't have the shield presumptively, you have to earn it.
So you wouldn't just be granted. So you sort of change the presumption to something. You have to show yourself to be a good agent, to be a good company after a while. And then you would perhaps, we realize you're in good faith and getting back to more of what the original
if you do these 7 things,
then you might get it. That'd be an interesting hint. Now,
who knows? Like, honestly, I feel like we're in like Alice in the Wonderland at the moment. So I don't think, I have no faith that.
What about getting back to the lawyer? What about suing the hotel? Is there deep enough pockets there? Yeah. How did that work? Yeah. So how did that?
So I got a counsel, great plaintiff's lawyer in Texas, and like any good client on the other side, the hotel said it wasn't their employee, that it couldn't be vicarious responsibility. They accused Joan of recording herself for a payout. The invasive discovery, and it took about 5 years, and they finally settled, but it was a nightmare, right? So there was
Did they say it wasn't their employee at all, or the person was on a frolic?
No,
so it wasn't a fraud.
I don't know.
It wasn't them.
It wasn't our employee. We don't know who this is. You've got to figure it out, right? And so there goes then into discovery, which was like warfare for 3.5, 4 years. And I asked Joan, was it worth it, right? And her response was like, I'm not sure if it was worth it, like the settlement. She's just not sure. It was such heartache. It's
also true that a lot of these service providers will go offshore, so you can't even reach them to get this to be taken down, even if you did have how does that work?
Yeah, so like we're kind of scofflaws in the sense of like so many non-consensual imagery sites are located in the United States because we have Section 230, but in other places they're also
I see. So we are the offshore.
No, but there are some like in Russia and the Netherlands, which also, paying no attention. When Joan went to one of those non-consensual intimate imagery sites to ask them to take it down, a site that, as far as she could tell, was located in Russia said, "Sure, if you send me more nudes." Right. So, you know what I mean? Like the whole project was awful, like from like start to finish. Right.
Could you pay them? I mean, if you didn't want to give nudes, could you translate?
No, they didn't offer that. They wanted more nudes.
There's nudes only.
We won't share it, but if you masturbate for me on video, I'll give it to you. No, really, is what the person said. So, you're so vulnerable, and then you're made ever more vulnerable.
Wow. There's been a lot of talk recently about, just to pivot a little bit, about this topic of doxing and news gathering. And how do you see this working? What would you say the boundaries are between sort of actually engaging in a form of doxing that is coming close to, I guess, a form of harassment of some kind, or that could even become criminal, and just sort of the allegation that sometimes could be used to sort of chill journalism and news gathering? And what might be the differences in those areas? Given the sort of constitutional mandate in certain respects with regard to news gathering and its role in defamation law and in the sort of the level of protection that news gathering agencies do have.
Yeah. So the term doxing is often invoked to conjure up when people publish others' home addresses with their names, so they're able to be physically contacted. Sometimes it's also posting someone's cell phone number, which President Trump did vis-a-vis Lindsey Graham in 2015, just to say reach out if he pisses you off, which it was in some
Oh,
sense a
right. He
form
said
of,
he gave me his number because he was afraid he was going to lose the election, so he might need a job someday.
yes,
So he gave
but
me
he
his
was
number,
still
and I
pissed
kept
at
it.
him,
Right,
so
right,
we
right,
sort
right.
of had a doxer in chief, or do. But it's the ability to reach someone physically, or to actually reach them, right, rather than just naming them. And often in my work, we see, as you said, like doxing in the course of a cyberstalking campaign. So it's, a perfect storm of rape threats, death threats, lies like someone's a prostitute. You put up their home address and say they're available for sex, or put up fake ads impersonating, saying they're a prostitute and where they can find them. And so it's often in the context of a sort of broader harassment campaign. So we don't have laws. There are a number of states that have laws that criminalize doxing, but it's in the context where it's intending to cause like severe emotional distress and the fear of physical harm. So we don't have a federal statute. I've been sort of hesitant to work on some of these laws because I think they can run right into the First Amendment pretty quickly. And, right now what we're seeing are accusations that journalists writing about and naming government officials, we've seen government officials like Elon Musk call that doxing and try to weaponize it. And the U.S. Attorney of the District of Columbia, Ed Martin, has written a letter saying, hey, journalists, if you name Doge employees, you might have committed a crime. Now, that is not a crime, right? That's First Amendment news gathering, right? And so there's literally no law that's going to cover a journalist naming someone working at a federal agency and accessing databases. There is not a law, and there is not a law that would be consistent with the First Amendment to the extent that it's applied, right? So it's a strange distortion and manipulation and misappropriation of the idea of stalking and the idea of doxing that's often wrapped up in stalking that is really designed to go back to the theme of these series. It's just designed to silence free expression and expression on legitimate matters of public interest that I find pretty chilling.
Yeah. And consistent with that and the chilling, and just one more topic, and then we'll have some time for a few questions from the audience on deep fakes, and how does this all further work in sort of chilling if you can create these deep fakes and they can sort of present like this. Could it be the type of thing that there's just so much noise out there that you can have a hard time getting your signal through as to who you really are and what you're trying to say? And then you have come up with, to move toward a conclusion here, this great concept or term. Is it the liar's dividend? Is that do I have it correct? Is that what it is?
Yes.
Yeah. Tell us about that.
Yeah,
Tell
so
us about this, and then we'll take some questions.
Yeah, my co-author, Bobby Chesney, who is now the dean at UT Austin Law School, who's just a wonderful human being. We wrote a series of articles about deepfakes and the challenges for national security, for privacy, for speech and democracy. And, in thinking through the problem of deepfakery, it's not that we have never had fake photos. Like there's fakery and falsehoods ever since we've had imagery, but the problem with deepfakes is they're so incredibly hyper-realistic that it's even hard for someone like Connie Farid, computer scientist, to even detect the fakery. And what happens is that because we're swamped in the fake and the real, what we call the liar's dividend is, the dividend is this. Someone who has actually done something terrible, that's real, it's videoed, or there's audio. Because we're caught in a world in which there's so much fakery, deep fakes that are genuinely hard to detect, that person can then say, oh, it's just a deep fake. I know you have me on tape, taking a bribe, or I know you have me on tape assaulting someone.
But it's just bull. It's just nonsense.
Right.
It's fake.
But it's a way to leverage our epistemic, like disreality that we're kind of living through and be able to get out of it either way, right? On the one hand, you say, what's real is fake. And then you can create fakery yourself and make up your own universe, right? To serve your ends. And that's, the powerful, in the hands of the powerful, it's incredibly disturbing.
And that could be deleterious to the freedom of expression required for democracy and citizenship.
Exactly. So it's a lot of noise, as you said. Like there's so much noise and fakery. And we do live in a moment of massive disinformation and propaganda on mainstream channels. That is, it's you know, it's hard for truth to poke through, especially when what attracts us is the, you know, kind of negative and novel.
Well, that's for sure. Yeah, it draws everybody
Right.
in, so there's incentives to do it.
Yes.
Yeah. Well, Danielle, this has been wonderful. But why don't we first say thank you and then open for a few questions in the remaining few minutes we have. I think I saw one hand. I first saw Kevin Douglas was first. Go ahead. Yeah.
One, thank you for the presentation. There's so much that you shared that I had no idea.
Sorry,
So
you know.
Yeah.
Kevin, my apologies.
I'm fine with it. Knowledge is power, they say, and so I'm happy to learn more. I'm curious about, in response to Section 230 concerns with limitations of Section 230, if we have to take financial fines off the table, what about using injunctions as a response to finding out that someone's images have been put up online illegally? Why isn't that a tool, or is it a tool that's available to people who have those kinds of issues?
Yeah, so 230 covers in equitable relief. It just covers all relief, but I've written a piece called Privacy Injunctions that is kind of the initial, very first privacy law in the books in 1905. It was a New York statute passed after the Court of Appeals had rejected a young girl whose face had appeared on a flower in Peking, flower ad. And the Court of Appeals rejected her claim for a privacy tort, but the New York lawmakers 2 weeks later passed a law providing injunctive as well as criminal relief for the appropriation of someone's image without, without compensating them for a commercial purpose. And the equitable relief was at the heart of Section 50 of the New York Civil Rights Law. And so I think we need absolutely, equitable and injunctive relief is so often what victims most want, right? You can't undo the damage, but you can minimize the harm. And so I'm with you. I think we need way more, bring back the injunctive relief, writ large. So you and I agree.
Judge, and then Stephen.
I'm so glad that I was here to hear your talk, and I think now I'm going to buy your book. I'm wondering
Yeah,
if you think
look at that.
experts in this field about sort of the long-range game in terms of Doge getting access to government information.
Yeah.
The first order effect seems to be just to control it, paychecks or things like that.
Yeah.
The second order effect that I've been thinking about is some type of ransomware effective move. But do you think there's some desire to marry up these databases of information with the 10,000 points that you're thinking of, and is that something that we ought to be worried about as a third order effect of what's going on?
It might even be the first. That is to train, artificial intelligence, so synthetic. There's different kinds of ways what do we mean when we say the term AI? It's a marketing term, but one of the meanings is to create or synthesize data, right? So text, audio, video. You need a lot of data to train it. Right. And so one thing I'm seeing in my circles, and that's computer scientists and privacy scholars of all types, are saying that they're worried, and as I'm worried, but that the data is going to be, the whole gambit is data to train, private companies' AI, which should scare each and every one of us, right? So yes, I think it's already being used to fire people, right? Do I think they have a right to be in there? No, it's inconsistent with the Privacy Act's requirements that you need a legitimate reason consistent with the reason that they collect the data. And fraud ain't one of them. We have an exemption, but they're not a law enforcement agency. They haven't done the right things under the Privacy Act to get it. But I think we should worry about the third as being the first.
Thank you.
Stephen Wilkes.
Yeah, thank you for your comments. I thought they were very interesting. But one thing you haven't captured is sort of the interplay with culture. So in the European context, their view of privacy comes straight out of the Second World War.
Yes, it does.
And
Yes, it does.
specifically how data was used at scale by the Nazis.
To find the Jews.
Right? And I wonder whether
Thank you.
part of what we're going through is kind of a need to maybe touch the hot stove on the side of the Atlantic and understand why, where the Europeans have actually come from on privacy and why they treat it differently.
Yes.
They live in that hellscape.
That's a great point.
Thank you.
Because we haven't had,
Yes.
and maybe,
I
mean, the thought is that, my grandmother would say you need to learn sometimes you need to
Hard
learn
way.
the hard way.
But that touched the hot stove. Is that what you would say? Yeah.
And the allies, totally. And thank you for raising it, because one of the bombing campaigns that the allies engaged in was to, the census data that was used to identify Jewish people were held, like Denmark had, or it was the Netherlands, like one of the countries had like the most expansive census data, and one of the first acts of the Alice was to blow it up. Like it was so dangerous, that data, that the intervention was to destroy it was like IBM match cards. So it was like the early form of computerization, right? The IBM systems that had brought that census data together. So you're absolutely right, we know that data is directly connected with genocide, right? Like identifying people who are the others who should be murdered, right? And, your wonderful question is like, are we gonna have that moment? I think we're seeing it unfold a bit, right? With ICE and with all the ways in which we were trying to identify students who haven't even engaged in just speech that's truly speech, right? Like the Columbia grad student who's getting deported for literally just engaging in speech, right? And so I think we're gonna start to see more and more of those stories. And I hope that we have the oh shit moment that the Allies certainly saw as data as being central to genocidal attempts. So thank you for raising it, because it's so true. It's why in Europe we think of privacy and dignity and speech as all rights that enjoy equal footing.
We have
Thank
more
you.
questions, but we are, unfortunately, I believe, out of time. So why don't we once again say thank you to Professor Citron.
I see my friend in the back. The woman.
What's that?
There's a cute woman in the back with pigtails, so I'm gonna. She had
Oh, yeah.
Patient up. I'll talk to her.
You want to talk to? Oh, she
I'll
can.
give 2 seconds.
Come up for your fight. Come on up.